Jennifer Hoffman versus Colin Miller. Attorney Corey Volmering for defendant. Plaintiff is not here.
Good morning to both of you.
Good morning, Your Honor.
Good morning, Your Honor.
We do note that we had waited now 12 minutes. The matter was set for 8:30. The plaintiff has not appeared. So we'll proceed. Mr. Volmering, do you wish to make an opening statement or simply proceed to proofs?
Simply proceed to proofs, Your Honor. And I don't know, considering this is a family case, I'm not really sure, but I think legally this case might be summary disposition in this case might be appropriate, considering there is not a valid defense claim, nor is there any prima facie evidence to suggest that the facts alleged are disputed.
Well, that may be, but unfortunately, the Court of Appeals tells me I still have to make a determination on the factors. So
understood. Thank you.
We'll go through that, get that done. It should be more expeditious, but we still need to make that determination. Go ahead, Mr. Volmering, when you're ready.
Thank you, Your Honor. Good morning, Colin. How are you today?
Not too bad. How are you doing, sir?
I'm good, thank you. All right. Can you tell me what county you presently live in?
I currently live in Calhoun County.
Okay. And does the minor child Lucas live with you currently as well?
Yes, that is correct.
How long has he resided with you in your care?
For the past few years, I'd say about 4 years or so.
You have to give that to me again, sir. You're a little echoey, so it's fine. It's hard to hear you. So if you can speak up so that I get all that information.
Approximately 4 to 5 years, I would say.
Okay.
Thank you.
And has mom exercised any time within those 4 or 5 years? Any parenting time?
She has. We started out doing, he was primarily with me through the week, and she would get him every other weekend up until this past year, or last year, I should say. Christmas Eve was the last day that she physically seen him. Last communication I had with her was on March 26th of this year. And we were going to meet up at a park that was halfway between our residence. And she texted me to let me know that she and her husband were both sick and were unable to attend. She wanted to FaceTime, and from what I recall, they did FaceTime that night. But after that point, I've had zero communication with her. She hasn't asked to see him or anything of that sort, or to exercise her parenting rights.
So the plaintiff in this case hasn't even talked to Lucas since March of this year, potentially.
That's correct.
And then the time before that, it was Christmas Eve of the year prior, correct?
That is correct.
Okay, thank you. Now, when Lucas is with you, does he look to you for guidance and supervision and support?
Yes, he does.
In what ways does he do that?
Well, he's, starting to become a pre-teenager, so he's, had some few questions here and there when it comes to, growing up and coming of age, and I've been able to provide that guidance for him. We've had a lot of coaching lessons since he's, been in school and stuff. He's been in some predicaments where, not quite the right decisions, but coaching him and mentoring him on if, he's in those situations again on what to do moving forward, and trying to do my best to shape him into being a very well-developed young man.
All right. And does he seem pretty receptive to that guidance and coaching?
Yes, he does.
And what is your understanding of his happiness in your care?
I feel like he's very happy. He's got a little brother here that he plays with every single day. We're very family oriented, so we're always, seeing different sides of my family and my wife's family. He has a great relationship with my wife's family, and yeah, he's a very happy child.
Okay. And he's doing okay in school?
Yep, he's doing a lot better. When I first took over of him, 4 or 5 years ago, of him going to school with me, he had kind of a slow start. He was pretty behind on a lot of things, but he's been making very good progress lately.
Okay, and you've been supporting him in that endeavor?
Yes, sir.
Okay. Do you love Lucas?
With everything I have
And do you tell him you love him?
on a daily basis.
Right. And do you provide Lucas with food, clothing, and medical care and other care as needed?
Yes, sir.
And do you provide medical insurance for Lucas?
Yes, sir.
Do you think that your residence where he's staying is appropriate, safe, and stable for him?
Yes, I do.
And does he have his own bed to sleep in at night?
Yes, he does.
Okay. And you said he has two step siblings, is that correct?
That's correct.
Okay. And does he get along with them pretty well?
Yep, he has a great relationship with him.
Okay. And how old are those two children?
My daughter Amelia, she is 6, and my youngest boy, he is 2.
All right. And
What was the age of the youngest one?
He's 2, Your Honor.
2, okay. I didn't hear, I'm sorry.
No, you're good.
all right. Let's see. Do you think that this proposed parenting time schedule and custody arrangement will promote a stable environment for the home and also provide a satisfactory relationship with both you and the plaintiff in this case?
Yes, I do.
Okay. Do you think that you are morally fit?
Yes, sir.
And are you physically fit to be able to take care of Lucas?
Yes, I am.
Okay. Where does Lucas currently go to school?
He goes to school at,
And is that in Calhoun County as well?
yes, it is.
Okay. And how old is Lucas now?
He is about to turn 11.
Okay. Has he said anything about either not being able to see his mom or wanting to see his mom, or did he say anything about, liking living with you, or how does Lucas understand this dynamic here with the plaintiff?
I've been very open and upfront with him. I believe in a strong communication with him. It also builds that trust as well. Any messages that I've received from his mom, I've always shown him, and he's been able to visually see that himself. I'm not holding anything from him. I never talk bad about his mom. When she first, trying to think of how to word this, when everything was first happening to where she just all of a sudden wasn't there and present with him, he was asking about her a lot, like, where is she, why doesn't she call me, and anything of that sort. And I was always there to, comfort him and guide him. I told him that, anytime he wants to pick up the phone and call her, he's more than welcome to do that. We've tried a few times and she never answered the phone. But as of lately, in the last few months, he hasn't really asked about her. He knows that this pursuant case is just more for his protection. That way, she can't just say, oh, he's coming with me with, and now wants to exercise her rights out of nowhere with all that.
Sure. But you have no issues potentially letting mom have some parenting time if she were to reach out and ask for that.
No, I do not. If it does go that way, and that's the route that the court would like to take, the only thing I would ask is more for like supervised visits, just to make sure that everything is taken care of for his sake on her end is all.
Has there been any domestic violence in your home?
No, sir.
Do you know where mom lives currently?
Last known over in Covert, Michigan.
About how far of a drive is that from your residence?
It's probably a good couple-hour drive. I know it's over on like the very far west side of the state.
Okay. And just to get this on the record as well, what is your current employment?
I work full-time at Tenneco. I am the operations lead there. And also I'm in the Army National Guard. I've been serving for the last 10 years now. Sergeant, about to be a staff sergeant there.
Nice, congratulations.
Thank you.
All right, what is about your annual income?
Annual, approximately together, probably around 55,000 a year.
How about just you?
Yeah, that is just
Oh,
me.
that's
Between
okay.
my full-time job and then National Guard combined is approximately, I would say, about 55,000.
Okay. You said you provide health insurance for Lucas, correct?
Yes, sir.
Any daycare costs?
Yes, he attends, it's like a daycare center at his school, before and after school care.
How much does that cost you per month?
Per month, about 250. They charge on a weekly basis. It's 75, or excuse me, it's $50 per week. So yeah, about 200 to $250 a month.
Okay. Do you have any mandatory uniform that you have to pay for, or any dues that you're required to pay for your employment?
No, I do not.
Okay. I have no further questions, Your Honor.
Sir, if you would, let me know how, at your current address, how long have you been at that address?
I'd say off the top of my head, about 3 years.
3 years.
Approximately.
Have any intent to change that, or is that where you're going to be staying?
We've been kind of rattling around the idea of, finding a house out in the country with some more property, but nothing currently set in stone.
Are you currently, you talked about the significant other, are you currently remarried or married?
Yes, Your Honor.
Okay. And how long have you been married?
We've been married for a little over about a year and a half now.
What, let's say during this time that you've had Lucas in your care, and let's focus on the last year. Has the plaintiff contributed or assisted you anyway financially?
No, Your Honor.
Has she, even though has she asked you at all about providing any assistance, like, well, you need anything, et cetera?
No, Your Honor. I've never asked myself, or never asked her of anything.
But I'm saying, has she asked you about contributing and say, hey, can I help, or is there anything you need? Has she done that?
No, Your Honor.
Is there anything else that you believe the court needs to consider or take into consideration in making its decision?
Are you addressing myself, Your Honor?
No, I'm sorry, are you talking to me or Mr. Miller, Your Honor?
Mr. Miller.
No, I don't believe so, Your Honor. I think everything has been laid out there and is true.
Have you had over the let's just say the last year or so, have you, other than that the time on Christmas Eve and then the phone call in March, have you had any interaction with the plaintiff?
No, Your Honor.
So fair to say you're not aware of any of her circumstances, living arrangements, or family, or anything of that nature?
No, Your Honor.
Okay. I don't believe I have anything further than anything as a result of my questioning, Mr. Vollmering, that.
No, Your Honor, thank you.
Okay. Okay. Any additional evidence or proofs, Mr. Vollmering?
No, Your Honor, thank you.
Thank you. Well, in this matter, the court will note for Mr. Miller's edification. In these cases, the court has to determine where Lucas will reside, and I have to do that based upon the best interest of the child test as delineated under the Child Custody Act, being MCL 722.23, and I'll address all of those factors in just a moment. The first task, however, of the court is to determine if an established custodial environment exists. An established custodial environment exists if over an appreciable time, the child naturally looks to the custodian in that environment for guidance, discipline, necessities of life, and parental comfort. The statute provides that the court can consider the age of the child, the physical environment, and the inclination of the custodian of the child as to the permanency of the particular relationship. It's important because when the court determines an established custodial environment, that the court cannot change that established custodial environment except upon presentation of clear and convincing evidence. If in fact there is no established custodial environment, then it would be basically a preponderance of evidence. And so in this particular case, the testimony has clearly shown that Mr. Miller has had almost a sole custody of Lucas for approximately the last 4 to 5 years. That again, it's shown that the plaintiff's involvement has been minimal in this particular time, and in fact, during she last saw Lucas on Christmas Eve 2022, now almost a year ago. That she was supposed to see him on March 26, 2023. She called and was sick, and since that time has not called nor has she seen him in this particular case. The court will note that, again, Mr. Miller has testified about the relationship he has with Lucas, that he mentors him, that he helps him with questions as he's becoming older, and questions and issues that might exist and come up. And what the court will do is looking at all of the evidence in this matter, and in some cases, in fact, the lack of evidence on behalf of the plaintiff, the court will consider that the established custodial environment for Lucas does exist in the defendant father's home. What that means is that the defendant then only has to show by a preponderance of evidence that it would be in the best interest of Lucas to remain in his care. The court go through the particular factors. The first factor is the love, affection, other emotional ties existing between the parties involved in the child. Mr. Miller testified that he does have a loving relationship with his son, that he tells him he loves him, and the court will note that, again, there's a absence of a relationship with the plaintiff, so the court will find that this factor does favor the defendant father. Next factor is the capacity and disposition of the parties involved to give the child love, affection, guidance, and continuation of the education, raising the child in a particular religion or creed. There's been no testimony about a religion or creed. The court will not consider that. Court does note that Mr. Miller did testify about Lucas being behind when he got custody of him approximately 4 to 5 years ago, that he's been working on that Lucas has made improvement, making progress in this matter. So court will note that, again, that he has been the one to continue him in the education. Court will note that two factors, capacity and disposition, and clearly the plaintiff would have the capacity to provide love, affection, guidance. However, the fact that she has been totally absent from Lucas's life, at least for the last year, and prior to that on a more limited basis, shows that she has not demonstrated the disposition to provide him with love, affection, guidance. Court will find that this factor does favor defendant father. Next factor is the capacity and disposition of the parties involved to provide the child with food, clothing, medical care, and other remedial care recognized in place of medical care, as well as material needs. The testimony of the defendant has been that he has and pays and provides health insurance, medical insurance for Lucas. That fact that he has testified that that in the last year, the plaintiff has not contributed at all financially. She's not even asked in this matter about contributing financially and has not done so. And that he has been solely responsible for the material needs of Lucas. The court will find that this factor does favor the defendant father. Next factor, the length of time the child has lived in a stable, satisfactory environment and the desirability of maintaining continuity. Mr. Miller has testified that he has lived at the current address for approximately 3 years. He'd like to move to the country, but there are no particular plans to do so. And we have no evidence from the plaintiff as to her circumstances. The court will find that this factor does favor the defendant father. Next factor is the permanency of the family unit of the existing or proposed custodial home. In this matter, the defendant testified he's been married for approximately 1.5 years. That in this particular matter that he has their stepchildren that Lucas has a good relationship with. He has 2 stepchildren, ages 6 and 2, and that Lucas, in fact, has a good relationship, plays with them every day, etc. It does appear that this family unit, the permanency of it does exist in the home of the defendant father. The court will find that that factor does favor him in this matter. Next factor is the moral fitness of the parties involved. The defendant testified there are no issues about his moral fitness. We don't know anything about the plaintiff in this matter. He also testified that he is a good physical health, and the court notes that he's testified that he does work full time. He's also in the Army National Guard, and was that Army National Guard or Air National Guard, sir? I might have.
Army National Guard.
Okay, I had it right. I wasn't certain. The reason I ask is most people in this area are involved in the Air National Guard. That's why I had to ask.
Yep.
That he does that, obviously, court's well aware of the stuff that he has to do on an annual basis for that, obviously, so he's in good physical health. The court will note that the court has not heard any testimony or any evidence from the plaintiff or on her behalf. In this matter, the court will find that as to those 2 factors, that they do weigh slightly in favor of the defendant father. Next factor is the homeschool and community record of the child. Obviously, I've heard very little testimony about the home and the school record, other than that, in fact, he has been improved since the time he's been in the defendant's care. We've not heard really much as to a community record. The court will find that this factor does slightly favor the defendant father. Next factor is the reasonable preference of the child. The court considers the child to be of sufficient age to express a preference. I did have a chance to talk to Lucas, found that he was very polite, that he was had expressed a preference. The court is taking that into consideration. Next factor is the willingness and ability of each of the parents to facilitate and encourage a close and continued parent-child relationship between the parent and the other child. We've not heard much or anything about the plaintiff's ability to, again, extend and to continue that parent-child relationship between Lucas and the defendant. We have heard some testimony from the defendant and stated that he would be open to the plaintiff having parenting time with Lucas. However, said they believe that it should be supervised at first to be, again, assured that everything was working in that particular situation. The court finds that that's to be reasonable when you haven't had contact with the child for a year, and likewise, they have no information concerning the plaintiff's environment, that it is appropriate that any parenting time would be supervised initially in these types of cases. The court will find that this factor does slightly favor the defendant father. Next factor is any other factors considered by the court to be relevant. There was the testimony concerning the stepchildren. The court is taking that into consideration, and then it sounds like Lucas does have a good relationship with them. The court is also taking into consideration, which again spills over into the other factors that I've already mentioned, but in this matter, the court looks that there has been a total abdication by the plaintiff over the last year and probably sometime before that, that she has, again, just simply relinquished and abdicated the total responsibility for the child to the defendant in this matter to the extent, unfortunately, that she hasn't had any contact whatsoever for approximately a year. The court will weigh that factor in favor of the defendant father. When the court weighs all of these factors, the court can give unequal weight to any particular factor. I don't have to weigh each factor in and of itself, but again, based upon the testimony, the evidence, and so in weighing those factors, the court will do so, but it does appear to this court, the defendant need only demonstrate by preponderance of evidence that it would be in Lucas's best interest to remain in his care. But after hearing the evidence, the court is convinced by clear and convincing evidence that it is in Lucas' best interest to remain in the care of the defendant father. So the court will award to Mr. Miller the sole legal, sole physical custody of Lucas in this particular matter. Court note that the court has to then consider the issue of parenting time, and so the court will do that based upon the statute, which is MCL 722.27A. In this matter, the court is required to consider those particular factors set forth under the statute. The first is any special circumstances or needs of the child. There's been no testimony about any special circumstances or needs, so the court will not consider that factor. Second factor is whether the child is less than 1 year old. He isn't. He's 10, soon to be 11 years old, so the court will not put any weight into that factor. Next factor is the likelihood of abuse or neglect of a child during parenting time. There's been no testimony about that, so the court will not consider that factor. Next factor is the likelihood of abuse of a parent during the exercise of parenting time. There's been no testimony about that, so the court will not consider that either. Next factor is the inconvenience or burdensome impact of travel on the child. The defendant testified in this matter that the plaintiff has moved away, that there's approximately, I think, that there is a distance. It's not a severe amount, but that there's approximately maybe an hour or so apart in this particular matter. So the court's considering that, but it's not substantial, so I'm not putting a lot of weight on it. Next factor is whether the parent reasonably expected to exercise ordered parenting time. Court will find that in this case, based upon the testimony and the total lack of communication and contact with the child, that the plaintiff would be reasonably expected not to exercise ordered parenting time. Next factor is whether a parent frequently failed to exercise parenting time. Yes, she has, based upon the testimony, and the court's considering that. Next factor is threatened or actual detention of the child. There's been no testimony about that, so the court will not consider that. Next is any other relevant factors. The court will find, as I've stated, that she's had a total lack of contact with the child for almost a year now. That, again, the defendant is not aware of or acquainted with whatever her situation is. And as a result, the court will find that, again, that there is not, at this point, there's not a basis for the court to order any parenting time. This time, court will note that that would be subject to any subsequent petition by the plaintiff should she choose to exercise her right to parenting time, but the court will note and state that at that time, it does appear that, again, all other factors being equal, that a phased-in period of time would be appropriate with some sort of supervised parenting time during a phased-in process. Again, assuming all other factors are equal. So I'm not saying at this point, I just say that that would be appropriate at that particular time, should the plaintiff come forth and seek to exercise some sort of parenting time. Next, the court will have to consider the issue of child support. The defendant testified that his income between the full-time work at Tenneco and the Army National Guard was approximately $55,000 per year. The court will, in this particular matter, note that we don't have any income as it relates to the plaintiff mother, but the court would note that in this particular area, as in other areas, that there is a substantial labor shortage, that as a result, that has caused that individuals can get a job almost anywhere that they'd like within a short period of time. Person going down the street could find at least 10 jobs in 1 hour based upon all the help wanted signs that are out, et cetera. And most of those jobs will pay at a start of $15 per hour. So the court will impute to the plaintiff full-time employment at a rate of $15 per hour for calculation of child support, and would in fact consider the defendant's income of $55,000 per year, also taking into consideration the medical insurance premium, a portion attributable to Lucas, which we didn't hear, but Mr. Vollmering, you can acquire that information and make that appropriate deduction. Likewise, you can take into consideration the child care of $250 per month for the after-school care. With that, Mr. Vollmering, is there anything else that you believe the court needs to address or has failed to address before we conclude?
No, Your Honor, thank you. I just to confirm though, do you want me to prepare this order?
Yeah, prepare the judgment and the UCSO.
Understood. Thank you.
Mr. Miller, best of luck to you. I hope everything works out for you, and you have a good day. We'll conclude at 9:16 a.m.
Thank you, Your Honor. You do the same.